If you could see from the tabs running across the screen, there are a lot of Supreme Court cases up here. I'm going to try to move through this pretty fast. Links to all of these will be in the description. So if you want to read through them at your leisure, you are more than welcome to do so. In my morning ramblin' while amblin', I talked about two prongs of a test for qualified immunity. I was mistaken a little bit. Well, you'll see why. This is what I was remembering. I graduated from law school in 2000. This is what I was thinking of. It wasn't a test. These are the rationales on which qualified immunity are based. The injustice, particularly in the absence of bad faith, of subjecting to liability an officer who is required by the legal obligations of his position to exercise discretion, and to the danger that the threat of such liability would deter his willingness to execute his office with the decisiveness and the judgment required by the public good. That's the rationale the court is using to that's the grounds it has to come up with the idea, the legal idea of qualified immunity, and why it's an important thing to have in federal cases based on federal statutes and the U.S. Constitution. So that's where I was coming from, and the doctrine has evolved pretty considerably, and it seems the more we move on, the more it's evolving. So this one I was also aware of when I was in law school. This is Harlow v. Fitzgerald. It's from 82. We therefore hold that government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person should have known. So there were, at this period of time, there was a subjective standard and an objective standard. The subjective standard is going to go away fairly quickly, but this is the objective standard, which is going to persist and morph with us. The next stop is Anderson v. Crichton. The holding in it is that the contours of the right must be sufficiently clear. The right that is being violated. It must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. So this is important. So the particular reasonable official, or the particular official, if the official was reasonable and doing that, that reasonable official would know they were violating a right. So if the official violates the right, then one of two things has to be true. Either it's an unreasonable official who didn't know that they were doing it, in which case you can proceed, or it has to be a reasonable official who did know he was violating the right, in which case you can proceed. But that the right has to be sufficiently clear that a reasonable official would know that what he's doing is wrong. So then Saussure adds to it, and they add in a first prong to now a two-prong test, because they got rid of the subjective standard. Now that all they have is an objective standard. And the very first thing you have to look at is, taken in the light most favorable to the party asserting the injury, do the facts alleged show that the officer's conduct violate a constitutional right? That's the first thing they have to look at. And then once they decide that yes, it has violated a constitutional right, if we assume that all the allegations the petitioner made are true, or the plaintiff made are true, then you go on to look at, is the right sufficiently well known enough? Is it clear enough that a reasonable official, that the official who violated the right, if that official were a reasonable official, would they have known that they were violating a right? And then Pearson doesn't really change a whole lot, at least in my understanding of it. This is in 2009. In Pearson, basically what they say is that the tests that Saussure made mandatory, step one, you check to see if if assuming all the pleadings as true, if the petitioner or the plaintiff violated a constitutional right. And then step two, would a reasonable official know they violated a right? Pearson says you could do those out of order, and you could maybe consider other things as well. So you don't have to just stick with those two things right at the top. You can mix and match the order and maybe add in other things. Then Ashcroft gets fun. We've discussed Ashcroft v. Kidd. They have material witness warrants. If there's going to be a material witness you think won't show up, if you're a law enforcement or whatever, if you're a prosecutor and you think a material witness won't show up, you can get the court to issue a warrant which will allow you to arrest that material witness. I know it sounds terrible, and yeah. And then in this particular case, Al Kidd was a material witness, or Ashcroft thought that Al Kidd would be a material witness in the 9/11 attack, and Ashcroft had a material witness warrant issued. They arrested Al Kidd. They released him on bond, but ultimately, at the end of the day, they never used him in any trial. So he sued, and that's why we now have Ashcroft v. Al Kidd. But the interesting thing is that it changes some things. So a government official's conduct violates clearly established law when, at the time of the challenged conduct, the contours of a right are sufficiently clear that every reasonable official would have understood that what he is doing violates that right. So it's a change from a reasonable official, meaning the official who's doing the thing, to every. So it has to be sufficiently clear that every official would have known that that's a violation of a constitutional right. And it also goes on to say, which I think is interesting, we do not require a case directly on point, but existing precedent must have placed the statutory or constitutional question beyond debate. So precedent is different than persuasion, but then it goes on to say that it's talking about district judges' opinions, that they're not controlling authority in any jurisdiction. Hint, hint, Granite State. Your district judge's opinion in, oh God, what the hell's the name of that case? The Veritas decision is not controlling authority. It's persuasive. Falls short of what is necessary absent controlling authority. And it defines controlling authority as a robust consensus of cases of persuasive authority. So under Ashcroft v. Al Kidd, if 6 other circuits have made a determination about what is a violation of somebody's rights, that should work under Ashcroft v. Al Kidd. But we'll find that has changed. Then Molyneux v. Luna. I like this one. It was a good kind of overview of the general consensus of what it is in 2015. The doctrine of qualified immunity shields officials from civil liability so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person should have known. A clearly established right is one that is sufficiently clear that every reasonable official, see it's stuck in there, every now, would have understood that what he is doing violates that right. We do not require a case directly on point, but existing precedent must have placed the statutory or constitutional issue beyond debate. So they're talking about precedent there. Put simply, qualified immunity protects all but the plainly incompetent or those who knowingly violate the law. We have repeatedly told courts do not define clearly established law at a high level of generality. The dispositive question is whether the violative nature of the particular conduct is clearly established. This inquiry must be undertaken in light of the specific context of the case, not a broad general proposition. Such specificity is especially important in the Fourth Amendment context, where the court has recognized that it is sometimes difficult for an officer to determine how relevant legal doctrine, here excessive force, will apply to the factual situation the officer confronts. So you notice in here they're not talking about a persuasive, a robust collection of persuasive authority. They're requiring it to be on point. And this is 2015, so bear that in mind. Then I threw Hine in here. It's from 2014, but Hine says that it can be, the officers can be mistaken in fact or in law, as long as it's a reasonable mistake of fact or a reasonable mistake of law. As the text indicates, and we have repeatedly affirmed, the ultimate touchstone of the Fourth Amendment is reasonableness. To be reasonable is not to be perfect, and so the Fourth Amendment allows for some mistakes on the part of government officials, giving them fair leeway for enforcing the law in the community's protection. We have recognized that searches and seizures based on mistakes of fact can be reasonable. The warrantless search of a home, for instance, is reasonable if undertaken with the consent of a resident and remains lawful when officers obtain the consent of someone who reasonably appears to be but is not, in fact, a resident. By the same token, if officers with probable cause to arrest a suspect mistakenly arrest an individual matching the suspect's description, neither the seizure nor an accompanying search of the arrestee would be unlawful. The limit is the mistakes must be those of reasonable men. But reasonable men make mistakes of law too, and such mistakes are no less compatible with the concept of reasonable suspicion. Reasonable suspicion arises from the combination of an officer's understanding of the facts and his understanding of the relevant law. The officer may be reasonably mistaken on either ground, whether the facts turn out to be not what was thought, or the law turns out to be not what was thought. The result is the same. The facts are outside the scope of the law. There is no reason under the text of the Fourth Amendment or our precedents why the same result should be acceptable when reached by way of reasonable mistake of fact, but not reached by way of reasonable mistake of law. I don't know why I threw that in here, to be perfectly honest with you. Because this one wasn't talking about qualified immunity. I don't know. I don't remember. I'm sorry for the brain fart. I think I threw it in here because it was cited by somebody, and it really made my noggin jog. And I don't remember why. Screw it. I'll leave that in there because I thought it was interesting. It doesn't really line up, but I thought it was interesting. Anyway, back to the actual qualified immunity cases. So the City and County of San Francisco v. Sheehan. This one is a really good read because it goes through a lot of the differences in what they're looking for between like the fact patterns. They used Graham v. Connor, and so to begin with, nothing in our cases suggests a constitutional rule applied by the Ninth Circuit. The Ninth Circuit focused on Graham v. Connor, but Graham only holds only that the objective reasonableness test applies to excessive force claims under the Fourth Amendment. That is far too general a proposition to control this case. And then they go on to say the difference between giving someone, withholding sugar from an innocent person, or dealing with someone who's dangerous and obviously unstable. They're two entirely different things. So this is a good case to read that shows you the particularity at which the Supreme Court's looking, which is bad if you're trying to sue cops, because you really have to have something on point. And what really is making my noggin jog on this is, so far, the filming the police in public cases have been filming the police in public forums cases. So the next time something happens, if you're filming the police in a non-public forum, are those cases going to be controlling? But it gets worse. It gets worse. And I didn't want that portion of it. But even if, this is where it gets worse. Moving beyond Graham, the Ninth Circuit also turned to two of its own cases. Then it continues. But even if a controlling circuit precedent could constitute clearly established federal law in these circumstances, it does not do so here. It is saying that what it's saying is that it's not clear at this point if a controlling circuit precedent constitutes clearly established federal law. I want to let that sink in a little bit. As far as qualified immunity, it is saying that there is a chance that controlling circuit precedent, like if you're in the First Circuit and you want to rely on Fordyce versus Seattle to pierce qualified immunity, you may not be able to. You may not be able to. And that, I'm not saying you can't. I'm saying that the court put that in there. It said, but even if, and the court says that for a reason. And I don't know exactly the reason why it said that, but that's a little scary. I saw that and I was like, wait, what? What do you mean? But even if a controlling circuit precedent could constitute clearly established federal law in these. Wait, what do you mean? So I don't know if they're focusing on the in these circumstances or what, but that's a little scary. And then they have verbiage that they threw in down here, the robust consensus of cases, but I'm going to look at it over here in Taylor v. Barks. This is also 2015. No decision of this court establishes a right to the proper implementation of adequate suicide prevention protocols. No decision of this court even discusses suicide screening or prevention protocols. And to the extent that a robust consensus of cases of persuasive authority in the courts of appeals could clearly establish the federal right respondent alleges, the weight of the authority at the time of Barks' death suggested that such a right did not exist. So okay, here's a real problem. Here's a real problem. It says, to the extent that a robust consensus of cases of persuasive authority could itself clearly establish a federal right. So it's not saying that it can. It's not saying a robust consensus of cases can clearly establish a federal right. It's not saying that. It's saying to the extent it could, to the extent that it could. Like, to the extent that I could fly, I'm not a very good pilot. Well, you can't fly. Well, I know. To the extent that I could hold my breath for 10 hours, well, you can't hold your breath for 10 hours. I know. So what this is saying is that it may be that having robust persuasive authority would be like circuit court cases from other circuits. So let's say that you're in a circuit that doesn't have a case like Fordyce or Turner v. Driver or something like that, Glick v. Cuniff. Let's say that you're in one of those circuits, because some circuits still don't have a circuit ruling, a circuit court of appeals ruling on the right to film. If you are in one of those circuits and you say, well, look at all these other circuit courts that have come to the same conclusion, the conclusion I want, that may not make it established in your circuit. And it also may not be established in the existing circuits. What this means is that maybe, just maybe, and this is just my wackadoodle reading of it. So, don't get too excited because the Supreme Court hasn't said anything on it yet. But it might be that the Supreme Court is hinting that unless the Supreme Court has ruled on it, it's not clearly established. So we'll have to wait and see on that. But it appears it appears from just going through these cases like I have been. I've spent the bulk of today reading and analyzing Supreme Court cases on qualified immunity, and it seems as though the Supreme Court is very generous with qualified immunity. They tend to say that qualified immunity is proper on the various cases that I've read today. So it would not necessarily be a good thing. I mean, if you're a police officer, it'd be a great thing. It'd be absolutely wonderful to have it be essentially mandated that the Supreme Court has to rule on it in order for there to be a way to get past qualified immunity in that particular instance. But for everybody else out there who may one day be violated by not just a police officer, but by any other government official with discretionary powers, then, it really, it doesn't make me too happy. I understand that there is a balance required between protecting these people who have to make discretionary decisions from losing everything as the result of their job. I understand that. But at the same time, if you make it essentially impossible to get past qualified immunity, then why even have a 1983 in the first place? Now, obviously, I'm being a little, negative Nancy. There are lots of ways to sue things and in manners that, like if you're asking for injunctive relief or if you're suing a city or an entity, then obviously there's no qualified immunity. But it's a little unnerving, a little disconcerting that it appears that the Supreme Court is moving towards more and more qualified immunity, making it harder and harder to pierce qualified immunity. Anyway, that's all I have for you today. I've probably recorded for long enough. I've got qualified immunity cases coming out of my ears, and I think I'm going to have a glass of wine, and my wife is making pot roast tonight, so I'm going to enjoy that. Thank you very much for watching, and have a great day.